Hello, my name is Steve Glanstein. I'm a professional registered parliamentarian. I've got over 30 years experience in the field, and I work a lot with condominium, community associations, a few cooperatives, a couple of churches, and several unions. I'm a parliamentarian. I also act as a professional presiding officer, and I'm here to explain to you a little bit about avoiding some annual meeting blunders with respect to Hawaii's condominiums community associations. I do have a handout for you that you should have, and it does contain about 11 major areas where blunders have occurred, and I'm just going to touch on a few of them in the short time that I do have. Okay, first is very important. Pre-meeting planning is to know your documents. You've got to know those documents. If you're a board member, you're held to the knowledge of them. Make sure that you know, when is our annual meeting supposed to be held? Okay, what limitations do we have on continuing the annual meeting? What's our quorum? Does it have to be held at a particular spot? Okay. Also, what other rules have we adopted? Have we adopted any meeting rules? Okay. Well, okay, when you're planning this meeting, there's legal posting requirements. Usually management companies know them. Your attorney should know them. Make sure you comply with those requirements. Okay, one of the biggest surprises is to find out that the notice is invalid or it was improperly mailed. Okay, what about candidates? Sometimes there are candidates who are running for the board. Okay, they make statements. Those statements, if they're submitted in a timely manner, they're supposed to be sent out with a notice. Okay. What about an agenda? Usually the agenda for association meetings is located in the bylaws, but it doesn't have to be. Proxies must comply with statute. That proxy statute periodically changes. There are a few people out there who are still using an obsolete proxy form. That can cause some real grief if somebody in the audience finds out about it and they object to those proxies. Okay. Another point in the pre-meeting planning area is to make sure that you have enough administrative personnel to handle any issues at that meeting. Okay. Those administrative personnel may handle the tallying, the check-in, the voting. They may even handle calling the police if there's a reason to. Okay. Now I'm going to move to meeting check-in. In check-in, it's critical to have an up-to-date owners list. Okay, sometimes that owners list consists of multiple owners of a single unit. And if the fourth one shows up and they don't know, it doesn't fit on the line, that's not the owner's issue, that's management's issue. So they've got to make sure that owners list is up to date. Okay, they should have the proxies there and kept very secure in case there is an issue about somebody's proxy or they are revoking it. The logistics of the room should support formality. If you put everybody in a circle and people are choking each other, if there are any issues, it makes the meeting much more tense, and it makes people more tense. So we tend to look for an area where we have the board, the chair up at the front of the room, and then we have at least 8 to 10 feet between the people at the head table and the audience, if that's at all possible. In today's world with COVID, we need to make sure we socially distance, and we have to be aware that there may be limitations on the number of people who can be at the meeting. Okay. Last year, there were limitations on whether or not we could even have the meeting. Okay. As of today, this second anyway, we don't have a limitation on whether we can have the meeting. We have a limitation on the quantity of people who can be at the meeting. So it's important that you know what the legal requirements are for your meeting. They may differ depending upon the island. Okay. Another couple of things on the meeting control. Logistics, we like to have a single entry point, maybe multiple exits in case there's an emergency, but you want to make sure that people are not coming in from the street, from any place that you know that they are authorized and eligible to enter the room. Additionally, you want to control the handouts. You want to make sure that the handouts are official handouts at the check-in table, and you want to make sure you control the ballots. Leaving the ballots on the table with nobody looking at them is a recipe for disaster. Okay, so make sure that the administrative people control them and that they're issued to individuals who are entitled to them. If once you've issued to an owner who's entitled to that ballot, issuing a replacement ballot is got to be under very, very unusual circumstances and usually requires returning the ballot that got mutilated. I want to get into some conduct of meeting issues. Okay, the actual conduct of the meeting is, in most cases, with over 1,800 condominiums, it's the president who chairs the meeting, calls it to order, conducts it, the meeting gets adjourned. The vice president may do it if the president refuses to, is not there, or wishes to step down for any reason. Okay, the newest edition of Robert's Rules of Order, newly revised, is the 12th edition. It came out effective September 1st, and it is consistent with previous editions to say that the president does chair it, or the vice president if the president is not available or has to step down. It also has a provision for hiring for having a professional presiding officer. Now, a professional presiding officer would need to be approved by majority vote, and the president has to concur with it. There are other options where a professional presiding officer can be appointed over the objection of the president or vice president, but those are very unique situations associated with specific motions and specific types of contention. Now, in our practice, most of our practice has been to chair the meetings. So we have these two roles. We can be parliamentarian, where we advise the chair on how to conduct the meeting. And then we're usually seated next to the chair, in this case of COVID, 6 feet away. Now, when we're presiding, that's a little different role. It's kind of like you're getting two things for the price of one, because we are also parliamentarians. We know the rules, we know the procedure, but we would be independent presiding officers. We don't own in the building. We have no financial interest in the building or the association. Our client is strictly the association, so there's no real conflict of interest there, and we don't take part in the debate. So that would be a different role, and that is one that is authorized in Robert's Rules. Okay, we do have some other individuals. Occasionally, a property manager will chair the meeting, and most of the time it may work out fine. But a property manager, there's very few of them who have any credentials as parliamentarian. Many of them have become members. They've gotten some basic training, and there is a risk in that their attention at the meeting really does need to make sure that the administration is done correctly. They need to really make sure that that admins don't have issues, the ballot issues don't exist, that anything is taken care of there. So we tend to discourage property managers from chairing a meeting, except perhaps at a last resort. Okay. We do have meeting rules, and those rules are readily available, which override Robert's Rules, and they're designed to ensure that meetings run just a little smoothly. They do recognize the reality that condominium and community associations are different from the 19th century church groups that were used as the original basis for Roberts. So you will know those rules are available. Many associations have permanently adopted them. If they have adopted them permanently, it really needs to have been part of the minutes. Okay. And I'm going to talk a little bit about minutes. I have some time here. Who takes the minutes? Well, under Roberts, the secretary takes the minutes. However, most associations have a custom where the property manager or one of their employees of the management company takes the minutes. That's fine. Just label them recording secretary. What should the minutes have? Okay, well, the minutes for condominium community associations are much shorter than those of state or local boards. There's a different principle here. The minutes are supposed to be official action. What did they specifically do? And there's an article on minutes Real Estate Commission published, and if you use your handout 4G, item 4G will give you a link to what the minutes should have, contents of minutes. Again, think of it as official action, not somebody's opinion, not what we think should be there or what this person said or that person said. No, it's the official action of the organization. Okay, I'm going to move into some reports of officers. Okay, if you're a nonprofit incorporated in Hawaii, then your attorney can tell you about the statute, and that the president or chief officer is supposed to make a report about the financial status or activities of the corporation. That's hidden someplace in Chapter 414D, and it needs to be done. Obviously, it's very common for presidents to make a report at the annual meeting. Now, whether it should be written or verbal is entirely up to them. One of the advantages of written reports is that they can be short, sweet, and to the point. Okay, one of the advantages of verbal reports is that they're a lot easier to make sometimes. But one of the disadvantages is that if the longer the report goes on, the more the opportunity exists for motions coming out of that report, or for an extended dialogue to occur that doesn't really get your meeting done in an efficient manner. So you need to balance that. Understand there is a need to provide information to owners, but you also have to balance that reading the entire financial report has happened once is just not going to be appreciated. The treasurer's report, yes, I mentioned the financial report. I once had an auditor who thought he would read every single word in the entire audited financial report. And I was a new parliamentarian. I didn't know that. He had done that because somebody told him to do that. Nobody wanted him to do that. And they just had a habit of doing that, and people suffered through it. So I suffered through it the first time. The second time, that didn't happen. I had a very happy client when the auditor was basically told, no, you don't read the whole report. And he just announced the report was available upon check-in, and we just moved on. In many bylaws, they talk about reports of officers. And occasionally you'll see a report from a site manager or a committee. You'll see issues come up like that. Well, if you're dealing with an association meeting, first of all, the site manager, general manager, regular manager are not officers of the association. Those officers are usually well-defined in the bylaws. It's president, vice president, secretary, treasurer, possibly auditor, possibly assistants to those, assistant treasurer, assistant secretary, maybe even a second vice president. Okay? Those are the officers. So these other reports are not technically reports of officers. Now, in associations, when they talk about committee reports, those are committees of the association, which are very different than committees of the board. The board is a separate entity. Now, many associations want to make those reports. So what we do is we do what's called a motion to suspend the rules. We just don't make it really technical. We'll say something like, if there's no objection, we will hear the report of the general manager at this time. We might preface it to say, normally reports of officers only include those officers listed in the bylaws. However, it is our custom to have a report from the general manager. Therefore, without objection, the chair recognizes the general manager to make a short report. Now, we did have a case where the general manager's report was 45 minutes, and the rest of the meeting was only 30. Okay, so you want to make sure that you, in your planning, that you have some kind of limit or some kind of expectation about the length of time of those reports. There also is an opportunity to present those reports during a voting recess or after the meeting has adjourned. It's a little bit less formal. But keep in mind that you are holding everybody hostage to those reports if they don't want to hear the extended length of what it is. Now, when they have major building issues, it's understandable. They want to hear these reports. So you need to balance that. Okay, a nominating committee report. If they have a requirement to have a nominating committee, you need to follow it. Otherwise, fix your bylaws to match your operations. But some of the newer associations and even a few of the older ones have a requirement for a nominating committee to be appointed and to make a report, and that creates nominations. So make sure that you know your bylaws enough to know if those reports are necessary. Okay, another issue not usually as critical is appointing tellers. Sometimes they're called inspectors of election. Need to know your bylaws. Some bylaws actually provide that the board appoints 1 or 3 inspectors of election. Other bylaws will provide just the terminology, and they don't speak towards the appointment. We had a set of bylaws a few weeks ago that we saw that said if the inspectors of election are not appointed, then the property manager becomes the inspector of election. So you want to make sure you know about those requirements. What do you want to avoid? Okay. Avoid tellers who Avoid tellers who want to see every single proxy form associated with any percentage of common interest. One of my experiences was to have a teller who had a doctorate in statistics, and he insisted on counting individual ballots instead of percentage common interest, which was incorrect. Then we finally had to set it straight. The tellers need to be able to work with the administrative personnel because they do it 100 times a year. They know how to do it. The tellers or inspectors of election should be able to work with them. Now, there's a few guidelines. This is not an official state of Hawaii type of election. These are elections where you look at a ballot and you fairly determine what the wishes are of the individual casting that ballot. So things like check versus X. If an owner puts a check mark instead of an X, okay, do you know what the owner's decision is? Yes. So then you don't invalidate it. If an owner votes 4 times for 3 people and the teller can't determine who the owner is voting for, obviously that becomes an invalid ballot. So our advice to them is never, ever, ever deface the front of the ballot. If you're going to make a decision on that ballot, write on the back or attach a piece of paper. Best to write on the back, sign off on it saying why it's invalid, and then disclose it on the tally sheet to make sure there's no question as to why that was marked invalid. Okay, I'm going to move to nominations of candidates to the board. Got to make sure the candidates are eligible. One of our biggest problems over the years came when people got elected to the board and their eligibility was questionable. You want to make sure they're eligible. That's why an up-to-date list is important. That's why it becomes very, very critical to make sure you have those people up to date. What if somebody's name goes on the ballot, they get elected, and it turns out that they were not an owner? Well, now you have a vacancy. You don't go back to the last annual meeting and give the election to the next person. It doesn't work that way. Names pre-printed on the ballot. There's a lot of flexibility there as long as the owners don't object. Many associations have problems even getting board members, so they put whatever names they can on the ballot. Okay, that's fine. Just make sure the wording in the script says these names have been placed on the ballot to save time. If there's no objection, they will be nominated, and we will open up the floor for further nominations. Not a problem. Absentee nominations, no, you don't have to be there to get elected. Okay, that's not a requirement. You don't have to be there to get elected. And nominating speeches, usually we try to limit them to 2 minutes. Sometimes it's more. Keep in mind that the Gettysburg Address is 1 minute and 40 seconds and has lasted longer than any nominating speech. In other cases, the nominating speeches are deferred. They don't use them. They will basically use the statement by the candidates. A question and answer period. While that can be done, usually the rules limit that because that can turn into accusations. It can make your meeting turn into a real disaster. Isn't it true that there was a restraining order against you, such and such and such and such? And I have here a document that says that you did something or other, and then the next thing you know, your meeting goes south, and it becomes a big argument over whether that is indecorum, whether it's rude, whether it should be permitted. So the nominating speech, if an individual is making a speech, it's usually a couple of minutes. If they take a question, that's part of their couple minutes. So if they're going to accept the question, they're going to respond to something, that's all included in their 2-minute limit. And that's, of course, assuming that you have meeting rules that limit the length of time of the speeches. Without a rule, the nominating speeches can be up to 10 minutes. Okay, we'll talk a little bit about election of directors now. Okay, what are the terms? They're in the bylaws. What about vacancies? Generally, the board fills vacancies. If you're in the condo world, the board's limited on filling vacancies up to the next annual or a special meeting, which has been properly noticed and set up so that the individuals can run for the remainder of the term. Well, what happens if we have no meeting or we have no quorum one year and then they adjourn the meeting? Are these directors automatically off? Generally not. You'll find in most of the bylaws, and as well you'll find in the statutes if you research it, that directors serve until their successors are elected. What that means is you don't just get free. You're still there. We just have to be very careful if we skip an annual meeting that we don't mess up the terms. Okay, a couple other things on that. is be careful on the terms. If a secret ballot's required in the bylaws, do it. Under Roberts, if a ballot's required and you violate that, individuals can object to it. They can procedurally challenge that election even a year later. So if there's a ballot requirement, follow it. We usually recommend that our clients allow for waiving the ballot in the bylaws if there is no challenge. Okay, if there's a cumulative voting requirement, okay, that allows somebody to accumulate their votes and multiply more and vote more times for an individual. So if I have 3 positions open for election, they can vote 3 times for one person, not 1.6 and 1.4, but 3 times, as many times as their positions. Okay, if you don't have cumulative voting, be careful, because official action in many associations requires a specific vote, such as majority present. Okay, plurality vote means those who get the most votes when you have 3 or more candidates. Okay, quick check on ballot calculations is something I do. The total of the votes should not total more than what's there. It's that simple. If you're dealing with a removal in an association meeting, it becomes critical that you get some legal, some parliamentary help, because there is a statute that overrides a lot of that information. And as far as effective time, an election normally becomes effective at the moment that they're elected, unless the bylaws or some other law says otherwise. I've got a list of several new business items there. It's important to make sure that you get them from the appropriate people. If you have motions on the item number 9, if you have motions ordering action in violation of the bylaws, keep in mind that needs to be stopped by a ruling by the chair. Don't forget the approval of the management contract if it's required. Okay, in the condominium community association world, depending upon who's making it, you might have a surprise declaration or bylaw amendment. You want to make sure that you're prepared for that. You know what votes required or whether or not it's even in order. Okay, we've got a couple more items. Board organization meeting, who chairs it? The president is usually still the president and chairs that meeting. Sometimes we'll chair it. And depending on how the bylaws are worded, there is legitimate business that can be conducted. So keep in mind that in the condominium area, you need to post notice to these board meetings. So don't forget to post notice, as well as having an agenda of expected items. Generally, we advise our boards to just keep their organizational meeting to getting officers and then doing other regular meetings for getting substantive business. I've had a few where they've deadlocked the officer elections. Okay, the same officers would stay in. Sometimes an officer is no longer eligible if they've gone off the board. So you have to know the bylaws, because you could have a vacancy. As far as postponing the board organizational meeting, generally, if you need to have it after the annual meeting because of the bylaws, call it to order and then just continue it, or you call it to order, adjourn it, and then on the agenda for the next regular meeting, put down election of officers. Finally, a few more items. Post-meeting issues, check-in list, ballots, and proxy requests, they need to be preserved. There are statutory requirements you need to check with your attorney on that. You need to make sure that that's correct. If you get any election challenges or counting errors, you need to get immediate help, because there are specific procedures to handle that, as well as any kind of recount or petition or special meeting to authorize the recount. And one thing we do for our clients as part of our action is we will review the minutes to ensure that they properly reflect the official action. Okay, this concludes my presentation. I believe questions will be solicited or available by email. Make sure you have the handout. It has my email available, and you certainly could send us an email if you have any specific questions. Thank you. And everybody be safe, and good luck having peaceful annual meetings.